Evening, and thank you all for coming. The faithful few who will hazard the 5 inches of snow that we've been predicted for this evening. I'm really, really grateful. But I think by the end of the presentation, you'll be really, really grateful that you came and knew about Clarke coming. Clarke Forsythe is an old friend of mine. He has been involved in the fight to preserve the protection of human life from the moment of natural conception, or from conception to natural death, for decades. And sadly, that's really where we're at. We're past the 30th anniversary of Roe versus Wade. Not only is he a very skillful appellate lawyer, having represented parties in front of the United States Supreme Court, as well as amicus, or friends of the court, he's a scholar of the law. And I'm particularly excited about having him tonight because he has just published last month a book entitled Abuse of Discretion. That is the title of his talk tonight. And those of you who are faithful Wall Street Journal readers will recognize the title because there was a tremendous review of his book in the Wall Street Journal just last week by Professor Jeffrey Rosen, which tells you that its content is such that it's meriting the attention of both practicing appellate lawyers as well as scholars of the law. And so, with no further ado, let me introduce Clarke Forsythe. Thank you for coming.
Thank you, Teresa, for the introduction, and thank you all for traipsing out tonight in the face of the predictions and of inclement weather. Hopefully we'll be done before there's any accumulation. As Teresa mentioned, last month I published Abuse of Discretion, the Inside Story of Roe versus Wade. And I suppose we've all over the years heard various stories about Norma McCorvey and Sarah Weddington, the woman who argued the case, and about the court. And if you read Woodward's book, The Brethren, that tells something about the Supreme Court at the time of the Roe versus Wade decision. But over the past 10 or 15 years, the papers of the justices have been released to the public. And Justice Blackmun's, for example, were released in 2004, and since then Justice White's and Justice Stewart's and Justice Rehnquist's have been released. And so sometime in 2008, I decided that a new book had to be written that could take account of the papers. And I've looked at the papers of 8 of the 9 justices who voted in Roe versus Wade, all but Chief Justice Burger's, which are still sealed and not accessible to the public yet. But I started this kind of journey back in 2008 when I was looking for the audio and the transcript of Roe versus Wade, which is available on a website called oyez.org, oyez.org. The Oyez is the part of the public greeting before the Supreme Court public sessions open. And you can go there and you can hear the actual audio and read the transcripts of Roe versus Wade. But I was also struck by the fact that in the anthologies that have been written, the histories, the compilations, the documents, I could never find anything about Doe versus Bolton. And Doe versus Bolton is the companion case to Roe versus Wade. And to understand the two cases, you have to read them together because the court said they are to be read together. And in Roe, the court said that there is a right to abortion from conception to viability, but then after viability, the states have to permit it if there is any health reason as determined by the abortion provider. But then in Doe versus Bolton, the court defined health to be, quote, all factors, physical, emotional, psychological, familial, and the woman's age relevant to the well-being of the patient, unquote. So in Doe, the court supplies the definition of health that the court said the states must allow it for after viability. And for 40 years, the court has dictated this definition of health as emotional well-being, which explains why you have to read the cases together and why together they set us on a radical, virtually unlimited abortion policy in the United States. And because of those two decisions, We are one of just 4 nations of 195 around the globe, just one of 4 that allows abortion for any reason after fetal viability, ranked with China, North Korea, and Canada. And that's been the rule, that's been the law since 1973 because of the Supreme Court and the Supreme Court's decisions. Now, the conventional history of Roe versus Wade is that it was well considered, that it was seriously deliberated, that it was considered with great care. At least that's what some of the defense that some of the justices have put up about Roe versus Wade over the years. But based on the papers of the justices that have been released over the last 10 or 15 years, based on the record we have today, that notion is no longer tenable. And I think, frankly, this is the most important book written about Roe since Roe, simply because these papers have been released to the public. They weren't available 10 or 15 years ago. And they're critical because they tell the story of what went on behind the scenes. And what went on behind the scenes is critical because there was no record in the cases. And lawyers and law students will understand the significance of that more than non-lawyers. But there was no trial, no evidence, no expert witnesses, no expert testimony or discussion of expert medical data. There was none of that because as I was shocked to find out when I first started to look into the papers, the justices took the cases in April of 1971 not to decide the abortion issue, not to declare a right to abortion, but to decide a mundane procedural or jurisdictional issue. All 9 justices were on the court in April 71, including Justice Black and Justice Harlan, and the justices took the cases to decide what lawyers know as the Younger case, but what is basically an issue about state and federal courts, just a mundane procedural issue. But then a crisis erupted in the court in September of 71, when Justice Black and Justice Harlan retired within the space of a week due to ill health. Justice Black died a week later. Justice Harlan died at the end of 1971. Both retired immediately. That reduced the number of justices to 7, and it flipped the balance of the court so that a temporary majority of 4 justices who were bent on eliminating the abortion laws were able to take these 2 cases, Roe and Doe, Roe from Texas, Doe from Georgia, that were taken to decide these procedural issues and use those cases to declare a right to abortion. And the first arguments were heard in December of 71, and these 4 justices pushed as hard as they could to eliminate the abortion laws before those vacancies could be filled by President Nixon in January of 1972 with Justice Powell and Justice Rehnquist. And the 4 justices, Brennan and Douglas and Stewart and Marshall, were able to create such momentum that even after Justices Powell and Rehnquist joined the court, they couldn't reverse the momentum toward eliminating the abortion laws, even if they had wanted to. And the fact that there were only that there was no record, the fact that there was no evidence, no trial, launched the justices on a trajectory that created a number of problems and made them susceptible to untested theories of medicine and law and history. I mean, without any record, without any evidence that normally ties judges to the facts, that ties them to some body of evidence. Without that, they were susceptible to certain notions of medicine. And where did they get these? I was curious about where did they get these? And by looking at the papers in the Supreme Court, the briefs, and by looking at the justices' papers, I was able to determine where they came up with a lot of the stuff that's in the opinion. Reading a judicial opinion is a little bit like following an email trail. You start with the opinion, and then you can find bits of the opinion in the arguments, in the oral arguments, or in the briefs, or in the record, or in the lower court's decisions. But with no record, you've got this opinion that goes on for something like 50, 60 pages, 70 pages. You've got 30 or 40 pages worth of history. But where do they get all this stuff if there was no record? And that's why the deliberations and the justices' papers are so important. Well, after Justices Harlan and Justice Harlan and Black retired, there was this 15-week vacancy before the vacancies were filled in January 72. And the court also decided by a 4-3 decision by these 7 justices, pushed by the 4 who pushed Roe versus Wade, they also decided a very critical case called Eisenstadt versus Baird, which took the Griswold decision in 1965, which said that married couples cannot be criminally prosecuted for using artificial contraception. And the justices extended that decision to even strike down limits on the sale of contraceptives to single individuals. So they took Griswold and they expanded it during this time of vacancy to strike down limits on the sale of contraceptives to single individuals. And then they used that case as a precedent, supposedly, for the abortion decisions. So there was a lot going on during that critical time. And the fact that the opinions that Roe and Doe happened at the end of the 1960s, and the sexual revolution, and the so-called population crisis, which was a national issue in the late 1960s, early 1970s, was a critical development. The conventional history of Roe versus Wade is that it was inevitable. It was the outgrowth of a body of prior cases and precedent. But I came to the conclusion it was really an accident of history, because it happened at the end of the 60s, sexual revolution and the so-called population crisis. But it also was an accident of history because it came during this short window of 15 weeks when there were these two vacancies. I argue in abuse of discretion that if Justice Black and Justice Harlan had been on the court, the cases might have turned out differently, because Black and Harlan likely would have voted against a right to abortion and left it to the states, or they would have dismissed these cases and looked for cases with some evidence and record. Or the cases might have come out 5-4 against, or even 6-3 possibly, against a right to abortion. So instead of this inevitable outgrowth of prior cases, I concluded that Roe and Doe were accidents of history. One of the key results of the fact that there was no record, no evidence, no trial, is that the justices latched on to this notion that abortion was safer than childbirth. Abortion is safer than childbirth. And the question that I asked is, how did they come upon this? If there was no record, no trial, no evidence, how did they latch onto this? Where did they get this? And it became apparent through looking at the briefs in the Supreme Court and the justices' papers that they got this through briefs filed in the Supreme Court by public interest groups or special interest groups such as Planned Parenthood, and through a number of medical articles or sources that they looked at, and they cite these in the Roe and Doe decisions. But if you look at these, sources, they are very weak, and I thoroughly critique them as basically worthless for supporting the notion that abortion was safer than childbirth. One is, for example, a letter to the editor in a medical journal. A couple of these articles don't even purport to compare childbirth or maternal mortality and abortion mortality. Some don't even claim that abortion is safer than childbirth. And if you look at the existing medical textbooks in the 1960s, the 6 or 8 of the most widely read, none of them claimed that abortion was safer than childbirth. And yet this drove the justice's opinion to a great degree. The notion that abortion was safer than childbirth was the key medical premise of the Roe and Doe decisions. It shaped the justice's notion of this historical right to abortion that they said existed. It encouraged them to prohibit health and safety regulations in the first trimester. believing that abortion was safer than childbirth. It encouraged them to expand the right from conception all the way to viability and beyond. And it encouraged them to defer to providers for any protection of maternal health, believing that abortion was safer than childbirth. And yet there was no reliable data whatsoever back in 1972 that abortion was safer than childbirth. And today, is there a board today, that the notion that abortion is safer than childbirth is still argued. Back in 1972, it was based upon Eastern European data from Eastern Soviet bloc countries. And it was based upon Hungarian statistics on abortion that was not peer-reviewed and not reliable. Well, today it's based upon comparing the childbirth mortality rate or the maternal mortality rate with the abortion mortality rate. And this is published by the CDC, and the abortion mortality rate is sometimes cited as something like 0.6 per 100,000, and the childbirth or maternal mortality rate is usually cited as something like 6 per 100,000. So if you just mechanically compare these, abortion looks 10 times safer than childbirth. And it's sometimes cited as that. But this is a rate, so it's a numerator over a denominator and a numerator over a denominator. But what goes into this numerator and this denominator is completely different. And what goes into this denominator and this denominator is completely different. So it's comparing apples and oranges. But it's been very useful in arguing that abortion is safer than childbirth. But they're non-comparable. They can't be compared because they're completely different. But that medical myth that abortion was safer than childbirth drove the outcome. And as I'll explain later, that notion that abortion is safer than childbirth is going to be before the Supreme Court this fall, hopefully, if the court takes a couple cases that are before it. Well, the other surprise that I came across in looking at the briefs in the Supreme Court and the justices' papers is that for most of the deliberations on the abortion cases, Roe and Doe, the justices were thinking about creating a right to abortion only during the first trimester, the first 12 weeks. And that was an assumption from the first arguments in December 1971 through the second arguments in October 1972. Typically, Supreme Court cases are only argued once. Rarely, but sometimes, the court asks for re-arguments. And so Roe and Doe were re-argued after Justice Powell and Rehnquist joined the court. They were re-argued in October 72. But if the justices were going to think about viability and creating a right up to viability, it was never mentioned in the first arguments or in the second arguments. It was never argued in the briefs. No medical organization that filed briefs in the cases argued that a viability should be a marker or a limiting factor, or that a right should be extended to viability. And I was wondering, where did they get this notion of viability? Well, after the second round of arguments in October 72, Justice Blackmun works on a second draft of his opinion, and he distributes it to all the justices as is common practice in November of 72. And in that second opinion, he again says that the decisive time is going to be the end of the first trimester, and that thereafter the states can prohibit abortion. But then the justices start negotiating and lobbying behind the scenes as to the scope of this abortion right. And in late November of 72, early December 72, Justices Powell and Marshall lobby Justice Blackmun to expand his opinion, expand what he's writing, expand the right from 12 weeks to viability, which at that time they thought was about 28 weeks. So they were considering expanding the right 16 whole weeks, 12 to 28 weeks, 4 whole months. And while they thought they had some data suggesting that first trimester abortions were safer than childbirth, they had no data whatsoever about second trimester or third trimester abortions. They were completely flying by the seat of their pants with respect to this expansion to viability and beyond. But yet, by early December of 1972, Justice Blackmun had agreed to expand the right to viability, and in December, around December 21st of 72, just 30 days, a month before the release of the decisions, he issues a third draft opinion which expands the right to viability. And that is basically how the court adopted this viability rule and created a right to viability and beyond. And it surprised me, and you can verify this yourself if you go to oyez.org, the word viability was never mentioned once in the first round of oral arguments or in the second round. Never mentioned once. You go to oyez.org, get the transcript, press F5, and input the word viability, and you won't find it. It was never mentioned once. And despite the fact that Justice Powell was part of the lobbying to get Justice Blackmun to expand the right to viability and beyond, and despite the fact that back in 1972 he was immensely proud of the fact, eventually he told his biographer that Roe and Doe were the worst opinions he ever joined. But unfortunately, he didn't realize that until years later. Well, by issuing such a sweeping decision, the justices also created a public health vacuum. Based on the notion that abortion was safer than childbirth, they prohibited health and safety regulations in the first trimester. And not only did they do that in 73, but in a couple of other cases through the rest of the 1970s, they basically said, we really mean this. And they struck down state regulations, health and safety regulations on clinics in the first trimester in 2 or 3 cases throughout the 1970s. Today, 40 years later, the court has yet to approve health and safety regulations in the first trimester. And there was a case before the Supreme Court, coincidentally until yesterday, a case from Oklahoma called the Klein case, which involved regulations on chemical abortions and RU46 that was up at the Supreme Court, had been appealed by the state of Oklahoma. And I was hoping that the court would take the case to, for the first time, approve health and safety regulations in the first trimester. But for reasons that I won't go into, the court dismissed the case yesterday, and it's no longer going to be heard by the justices. But as I'll mention in a few minutes, there are still two other abortion cases at the Supreme Court this fall. So in addition to prohibiting health and safety regulations in the first trimester, the justices also created a public health vacuum by expanding the right to viability and deferring to providers to provide to monitor health and safety up to viability. But they also created this one-way ratchet of evaluating health concerns. When the court talks about maternal health, it mostly is talking about maternal health concerns from not having an abortion, reinforced by this notion that abortion is safer than childbirth. Over the last 40 years, when the court has talked about maternal health, it's about maternal health concerns from delaying an abortion, having an abortion later and later in gestation, without considering what about maternal health concerns or risks to the mother from the abortion itself. And so for 40 years, the health concerns have been basically a one-way ratchet to the fastest abortion possible. And only in the last several years have the justices had the occasion to begin to consider medical data showing risks to women. There are now over 130 international peer-reviewed studies finding an increased risk of preterm birth after abortion. 130 international peer-reviewed studies finding an increased risk. Now, this data has to be handled carefully, in at least two ways. Number one, an increased risk is not the same thing as causation. An increased risk plus other factors can lead to a finding of causation, but an increased risk alone doesn't mean causation, that abortion causes preterm birth. We need more studies, more data to reach a decision about causation. But yet there are 130 studies finding an increased risk of preterm birth and future pregnancies after abortion. And these 130 studies are not just US data. It's not just on American women. These 130 studies cover women from 30 different countries. Scandinavia, Europe, Latin America, New Zealand, and Australia. And there are now 100 international peer-reviewed studies, over 100, finding an increased risk of mental trauma after abortion. And again, increased risk isn't causation. There needs to be more studies. There needs to be more analysis. And there are also studies, some studies finding no increased risk of preterm birth, no increased risk of mental trauma, and they obviously have to be taken into consideration. But the general theme you hear in the media is that there is no evidence whatsoever of any risks, or no evidence whatsoever of any long-term risks. And yet this body of data has grown over the last 20 years. It largely didn't exist before 1990 or 1992. We now have this body of data to look at that didn't exist back at the time of Roe versus Wade. And there are cases, again, before the Supreme Court that will allow the court to look at this body of data that they didn't look at in 1973 and didn't look at in 1992. Finally, the court created a public health vacuum by the fact that the court is a court. It cannot regulate. It cannot legislate. If the justices hear about substandard conditions in clinics in Washington, D.C. or Philadelphia or some other place, the court can't act as a legislative body. It can't regulate new health and safety regulations. It's completely dependent upon cases that are appealed to the court. It can't reach out and take a case. It's a passive institution. It gets 10,000 appeals a year. It takes about 80 cases and hears about 80 cases on the merits. But it's completely dependent upon cases being generated in the lower courts, coming up to the appellate court, and then being appealed to the U.S. Supreme Court. So the court can't legislate. It can't regulate. It can't step out to protect public health and safety as public health officers, federal, state, or local, can normally do. So the court really has created a public health vacuum that it can't really do anything about. It can approve health and safety regulations that the states enact, but it can't legislate them itself. And over 40 years, it has never yet approved health and safety regulations. So the court really can't do anything about this public health vacuum. Now, there's a lot of history in abuse of discretion, but it's not just history. Because, as I mentioned, there are 2 abortion cases before the Supreme Court this fall. The court has not yet decided to take the cases, has not yet decided to hear the cases, but they are pending before the justices, and the justices have yet to consider whether to take them. One of the cases is called the Pruitt case from Oklahoma. It involves using ultrasound as part of the informed consent process. Professor Collette is lead counsel in the Pruitt case, and the court may decide, or at least may consider this Friday, whether to hear that case sometime in the next couple of months. The cases go before the court in what they say a conference. The court conferences the cases and then decides whether to take the cases. And the Pruitt case is supposedly conferenced for this Friday. The court could decide to hear it, could push it forward and wait. We won't know until probably Monday morning. And then there was a second case from Arizona called the Horn versus Isaacson case. And that case involves Arizona's 20-week or 5-month limit on abortion. Arizona is one of 12 states that has passed a 20-week or 5-month limit on abortion. 12 states plus the U.S. House of Representatives passed a 5-month limit on abortion in June. And the Arizona case, Horn case, is the first of the 12 5-month limits that has reached the Supreme Court. Again, the court has not yet decided to hear the case, but it could hear the case in the next couple of months. Now, the Horn case, because it deals with late-term abortions, because it deals with abortions at about the time of viability, less 2 to 4 weeks perhaps, the Horn case could involve the justices in reconsidering the notion or re-examining the notion that abortion is safer than childbirth. Because even if it might be safer than childbirth in the first trimester, although I think that's doubtful, I don't think there's any reliable data, it's much less plausible that abortion is safer than childbirth when it comes to late-term abortions. In fact, there's a 2004 medical study by Bartlett which shows a greatly increasing maternal mortality rate from abortion after the first trimester. The rate of maternal mortality jumps after 12 weeks, it jumps by 16 weeks, and it jumps again by 20 to 21 weeks. And so this notion that abortion is safer than childbirth is certainly doubtful for late-term abortions, and the court may have to consider that as a working assumption. But secondly, the Horn case, because it prohibits abortion at 20 weeks LMP, 20 weeks last menstrual period, undercuts the viability rule, prohibits abortion before viability, and therefore draws into question whether the court is going to uphold this law or strictly apply the viability rule and say the states can't prohibit abortion before viability. So both the assumption that abortion is safer than childbirth and the viability rule could be before the court in this Horn versus Isaacson case. Now, these cases are very important, and personally I was disappointed that the Klein case was dismissed yesterday because I wanted the court to address the question of whether the states can regulate for health and safety when it comes to chemical abortions in RU 46. But that case is out of the picture. But these other two cases, the Pruitt case involving ultrasound, the Horn case involving the 20-week limit, are very important cases, and I certainly hope the court will hear them. But how should the court look at the 20-week limit? How should the court look at this 5-month limit that's in the Horn case? There are some who would say that because of the viability rule, the states just can't do this. Unless the court overturns the viability rule, then the court's going to strike down this 20-week or 5-month limit. And that could be the outcome. But I don't think it necessarily will be the outcome because the justices have expressed concern about late-term abortions. You may remember back in 2007, in a case called Gonzalez versus Carhart, the Supreme Court upheld the Federal Partial Birth Abortion Ban Act, which was passed by Congress and signed into law by President Bush. Well, the court in 2007 in the Gonzalez case not only upheld the Partial Birth Abortion Ban Act, but they also gave indications and instructions in part to the states and the lower federal courts about allowing greater regulation of abortion. The court expressed, at least the majority, Justices Kennedy, Roberts, Alito, Scalia, and Thomas, those 5 that formed the majority to uphold the Federal Partial Birth Abortion Ban Act, they expressed great concern about late-term abortions, not only the impact on the unborn child, but also the impact on maternal health. And for the first time, acknowledged that women who have abortions might, in fact, incur an increased risk of mental trauma after abortion. But they clearly expressed concern with late-term abortions. Well, the Horn case goes beyond simply a prohibition of a type of procedure and expands it to have a broader prohibition on late-term abortions after 20 weeks. How can the states do this? Well, first of all, the states drafted these 20-week, 5-month limits based on basically 3 factors. One is the guidance that the court was suggesting in Gonzalez and the concern for late-term abortions and the possibility of a broader prohibition on late-term abortions. Secondly, Arizona cited medical evidence, scientific evidence, that the unborn child can feel pain at or after 20 weeks. And the third thing that Arizona relied upon was the increased rate of maternal mortality from abortion after the first trimester, and the concern with maternal health, and the concern with the increased risk of maternal mortality from late-term abortions. So it's the guidance from Gonzalez, the evidence of fetal pain, and the concern with maternal health, and the increased rate of maternal mortality. Those are the three kind of factors or guidance that encourage the states to pass 20-week limits, especially Arizona's. The other states, coincidentally, relied solely on fetal pain and did not cite maternal health in passing the 20-week limits. So for that reason, Arizona's, the case that's up at the court, is very significant because they rely upon both fetal pain and maternal health. Now, the court historically has said that the states can limit abortion or regulate abortion in the interests of fetal life or in the interests of maternal health. But of course, the court has said that none of those can be decisive in prohibiting abortion until viability or after viability, and then of course there's that health exception. But Arizona will I think argue that a 20-week limit is constitutional under the court's current cases because of the interest in fetal life and the evidence of fetal pain, and because of the increased concern for maternal health. But I think there's also another factor, and that is that the timing of the trimester framework that the court created, the viability rule itself, the time in pregnancy when the court said that the states can limit abortion, is based upon the assumption that abortion is safer than childbirth. So it's not just a medical notion. The court relied upon it in creating its constitutional rules in Roe versus Wade and Doe versus Bolton. And if you undercut the notion that abortion is safer than childbirth, you really play with the complete framework of Roe versus Wade and Doe versus Bolton. The court has to reconsider the framework that it created and the assumptions that it was playing with in Roe versus Wade and Doe versus Bolton. So if abortion is not safer than childbirth, if abortion is more dangerous than childbirth in the second trimester, it heightens the proposition that the state should be able to prohibit abortion. And Arizona will cite that evidence and argue that to the Supreme Court. The other thing that's important about the Arizona case, the Horn case, and the 20-week limit is that it does undercut the viability rule. It arguably conflicts with Roe versus Wade because it doesn't obey the viability rule that the states can only prohibit abortion after viability. The state, in fact, Arizona, in fact, conceded that it was prohibiting abortion before viability. And the court may be faced with the question of whether to keep the viability rule or uphold the Arizona law. It's not necessarily either or, but the court may be asked to throw out the viability rule and uphold the 20-week limit. That would be huge because the justices have said that the viability rule is a basic premise or a basic foundation for the Roe versus Wade decision. And if the court cuts out the viability rule, then how do they define the limits of the states in prohibiting abortion? I'm assuming that we don't have a majority on the court that would consider overturning Roe versus Wade. But let me be clear here. In this case, or in any case in which an abortion law or regulation or limit, even a parental notice or consent case, In any case in which a law arguably conflicts with Roe versus Wade, the court can reconsider Roe versus Wade. Because, as Justice Scalia said in a case some years ago, in any case of that kind, the court either has to decide what standard to apply. Does it apply Roe versus Wade? Does it apply the Constitution? Or does it apply some other standard? And so the court could reconsider Roe versus Wade in one of these cases, although I don't think we have the 5 votes to do that. But there's this myth out there that you need the perfect case or the perfect prohibition or the absolute prohibition in order to spark a conflict with Roe versus Wade and induce the court to reconsider it. That's not accurate. The court can reconsider it in any case in which a law arguably conflicts with Roe versus Wade. So we'll have to see what the court does. In the Horn case, Horn versus Arizona case, the court could cut back on Roe a little bit. It could cut back on Roe somewhat. It could cut back on Roe a whole lot. We just, as you go into these cases, you really, you don't know what the justices are thinking. You don't know what's going to be persuasive. You don't know whether new facts, the political support by 12 states for 20-week limits, how that's going to influence the justices. You really just don't know. And so the outcome of these cases is uncertain. And as I mentioned, the court has not yet decided to hear these cases. So how are we doing on time? Okay. Well, abuse of discretion looks at what went on behind the scenes because I wanted to give the 2 generations that have grown up since Roe versus Wade a new understanding of the decisions. And the history you'll read about and what went on behind the scenes in the Supreme Court in abuse of discretion is unlike anything you've heard in the public venue up to now. It's a new history of what went on behind the scenes. And the court, since Roe versus Wade, but Justice O'Connor in 1983 basically said that the Supreme Court had donned the role of the National Abortion Control Board in Roe versus Wade and Doe versus Bolton because the court controls every aspect of the abortion issue. It controls every law that's passed in the states, whether parental notice and consent is allowed, whether abortion funding is constitutionally required or not, what goes into informed consent laws, what kind of clinic regulations can be passed. The court controls all of that and took upon itself that role. And in addition to all the other ways in which Roe versus Wade and Doe versus Bolton can be criticized, history, law, morality, philosophy, the court should also be criticized for its record as the National Abortion Control Board. What kind of record has it had? When you look at the Kermit Gosnell scandal in Philadelphia and the state-by-state, year-by-year scandals, I mean, Kermit Gosnell is certainly not the only scandal. Not only is it one of a long line of scandals involving late-term and live birth abortions, but there are something like clinics in dozens of clinics in something like 30 states now that are under investigation. And so abuse of discretion will give Americans a much better basis to analyze how the court has done as the National Abortion Control Board. Why should abortion, among all the public health issues in this country, be controlled by the Supreme Court? What justifies the court continuing in this role? 40 years later, those questions still need to be asked and answered, and that's why I wrote Abuse of Discretion. So thank you for coming tonight, and I'd like to answer any questions you might have. Thank you. Yes, in the back. I wrote it for non-lawyers. I wrote it for non-lawyers, and I tell as many stories about what went on behind the court as I could. I've a number of non-lawyers, friends of mine, have come back to me and says it's a good read. and that even though they're not medical experts or legal experts, that they were able to enjoy it thoroughly. So um, it's available on Amazon. That's the cheapest and quickest way of getting a hold of a copy. But you might also read Jeffrey Rosen's review in the Wall Street Journal that was published, I think it was 2 weeks ago Saturday. Um,
Who was it?
Jeffrey Rosen. It was entitled something like "The Choice the Justices Made." It was in the Wall Street Journal Saturday edition 2 weeks ago Saturday. But I really, there's been enough legal discussion of this issue over the last 40 years. There needs to be a new history that tells the story that the papers tell, and that couldn't have been written 10 or 15 years ago. So I tried my most to write it for non-lawyers, and hopefully I succeeded. Yes, sir.
The justices that voted for abortion, you get, the arguments can be pedantic and the longest, but what was the psychology of those four people? It seems like there's some psychological things about their demeanor, their sensibility about things. What is the root of that kind of decision psychologically?
Well, the four wanted to eliminate the abortion laws with different motivations. I'm not sure that there was one motivation driving all of them. You have to, as I lay out in the book, before the justices approached the abortion issue, they addressed the contraception issue. And they decided the Griswold case involving married couples, and then they decided the Eisenstadt versus Baird case involving limits on the sales of contraceptives to single individuals. They had eliminated all these laws without much public backlash at the end of the sexual revolution of the 1960s. And some of them thought that abortion was just the next step to expand privacy and autonomy. And we swept away those laws. We can sweep away these laws. There was I would say more than today, there was this optimism that the court can solve social problems. And this is a social problem with all these back alley abortions based on doubtful statistics, but that was part of what they were told throughout the 1960s and early 1970s. They felt they could solve these problems. I think the court today has much more of a realistic notion about what kind of problems judges can solve and the Supreme Court can solve. But back then, they felt they were in the social problem-solving business. That was part of it. The population crisis, or so-called population crisis, was a huge issue in the late 1960s or 1970s. You may remember Robert McNamara, who was Secretary of Defense in the Kennedy administration. Then he went to the World Bank. He would go around to international meetings and national meetings in late 60s, early 70s, talking about the population crisis in atomic bomb metaphors. He talked about the mushrooming cloud of the population crisis. And 6 months after President Nixon became president in July of 1969, he gave this national address, I'm not sure if it was on TV or to Congress, about the so-called population crisis. He appointed a commission called National Commission on Population and the American Future. And he made Nelson Rockefeller the chairman of this commission. No, it wasn't Nelson Rockefeller, it was John D. Rockefeller III. Rockefeller was funding the abortion litigation to eliminate the abortion laws. And in March of '72, while Justice Blackmun was working on his first draft of his opinion, the commission released a report on the front page of all the newspapers saying that legalizing abortion would help solve the population crisis, advocating that. So population crisis, sexual revolution, the personal lives of the justices were also involved. Justice Douglas had long wanted to wipe away the abortion laws. Justice Brennan's motivations, I'm not exactly sure. He's kind of an enigma. I couldn't really find his clear motivations. Justice Stewart, if you read Woodward's book, The Brethren, Woodward records that Justice Stewart thought that abortion was a good solution to the population crisis. Justice Marshall, had experiences in his life where he'd represented individuals, and he had his personal knowledge of women who had died in back alley abortions, and he felt legalization would solve that problem. So there were mixed motivations, based upon their own personal histories and the way they viewed the law and the role of the Supreme Court. Does that answer your question?
Yeah, I mean, you take somebody who takes a liberal, you put that a liberal stance like that, they're liberal about everything, seemingly. And that it's just curious how that liberal sensibility kind of, where that enters into a person's psyche and being, or is it, what it's all about.
Well, the four who pushed really hard to eliminate the abortion laws did not have a uniform judicial philosophy. Justice Stewart is, I suppose, historically considered kind of a moderate. He would go on in 1980 to write the decision that upheld the prohibition on federal funding of abortion and state funding on abortion. What I would call the first retreat from Roe versus Wade. So they had different motivations and different judicial philosophies, and but the personal and the pragmatic were clearly driving factors.
I guess what I'm driving at is, there's some of the things are intellectual in their
Yes.
formation. Some are not intellectual. They're personal experiences, psychology, personal issues that arise, or pushes somebody in a certain direction.
That's certainly true, but I don't really go at it at length and abuse of discretion, but the fact of the matter is that there were only two dissenters from Roe and Doe, Justice White and Justice Rehnquist, and they did not write strong dissents. They did not thoroughly go after Justice Blackmun's opinion. They were not pro-life dissents. They were kind of federalist dissents, meaning let's leave this to the states. The court shouldn't decide this issue. The court, there's no right to abortion in Anglo-American history. We don't have a right to create it. Let's leave this to the states. There was no opinion filed in the case that strongly said that the unborn child is a person or a human being protectable by the law or that should be protected by the Constitution. So those dissents were kind of a weak counterbalance to Justice Blackmun's majority opinion. If there were, if Justice Scalia or Thomas were on the court, back then they might have written much more robust dissents. So I think that was a factor in the outcome. Yes?
Well, a lot of this is centered around viability. Has all the advances in neonatal medicine in the last 40 years made any difference in
I thought you were going to ask another question. There has been some shall we say, retrenchment on viability. The justices thought it was at 28 weeks. Today it might be 23, 24, but you have to understand that viability is based upon medical statistics of predictions about the survival rate of unborn children at various weeks of gestation. So, and it's also affected by, whether you're talking about the University of Minnesota's hospital or some local community hospital in the middle of nowhere. So it's shaped by technology, but it's also, it's predominantly shaped by if this child's 20 weeks LMP, what is the rate of survival of children at 20 weeks LMP, or if it's at 22 weeks or 24 weeks? Is it a 15% survival rate, or is it a 40% survival rate, or is it a 60% survival rate? And it's just, it's a predictive enterprise by doctors. It's nothing that women feel or, unlike quickening or feeling fetal movement, it's the woman in pregnancy doesn't say, oh, I feel today that this child's viable. It's not something they feel. It's based on medical statistics. So there has been some movement, but I think it's questionable whether there'll be significant movement in the future. Again, it's a medical technology issue, really. Does that answer your question?
Yeah.
Yes, in the back?
So the current Supreme Court, and I don't even know how to ask this, but are they like that old Supreme Court in that they've been based on personal, or are they taking into consideration more information that has been gathered?
We have a Yeah, we have a court that's, that at least on the abortion issue, is now divided kind of 4-1-4. It's really on tenterhooks. There are 4 justices, Breyer, Ginsburg, Sotomayor, and Kagan, who presumably will vote to uphold a strict right to abortion, a broad sweeping right to abortion, and strictly apply Roe versus Wade, and presumably will vote to strike down a 20-week limit because it violates the viability rule. We've got 2 justices, Scalia and Thomas, who have outright made public statements in more than one case that Roe versus Wade is unconstitutional, it has no basis in the Constitution, it should be overturned. We've got 2 justices, Chief Justice Roberts, Justice Alito, who voted in 2007 to uphold the Partial Birth Abortion Ban Act, but have not publicly revealed their position on Roe versus Wade itself, and I think we'll take each case as it comes along. And then there's finally Justice Kennedy. Justice Kennedy, at one point, voted to overturn Roe versus Wade, and then kind of stepped back and did not do that. And then in 1992, he said that Roe versus Wade should be reaffirmed. But then there were 2 partial birth abortion cases to come before the Supreme Court in 2000 in Stenberg from Nebraska, and in 2007 involving the federal law. And I think all commentators recognize that though the reality of late-term abortions, the reality of partial birth abortion, seriously affected his evaluation of late-term abortions. Maybe not his inclination to hold to Roe versus Wade, but his concern about the impact of late-term abortions, his horror of late-term abortions, and a willingness to limit them. If the Arizona law is going to be upheld, it's going to be if Justice Kennedy, Roberts, Alito, Scalia, and Thomas join together, as they did in 2007, and uphold the 20-week limit. We don't have a pro-life Supreme Court, but I would argue that we have the most abortion-skeptical court, at least the most abortion-skeptical majority since Roe versus Wade. The 5, Kennedy, Roberts, Alito, Scalia, Thomas, are skeptical about abortion and abortion right more so than the court in Roe versus Wade. They are more deferential to the states than the court was back in Roe versus Wade. They are less willing to allow the American Medical Association and the American College of Obstetricians and Gynecologists to dictate what's medical standards or what medical practice should be, or abortion practice should be, or how to read even the medical studies. They are more willing to defer to the states if there are medical disagreements than to strike down state laws. So it's, like I said, and I think the best way to phrase it is the most abortion skeptical majority since Roe versus Wade. That's good as long as that majority stays. But if you take, if Kennedy, Roberts, Alito, Scalia, Thomas retire and are replaced by this president, the court will flip. The balance of the court will flip-flop. And we'll probably have 5 justices who will not cater to any regulations or limits. That's where we are today. I'm sorry that it's hard to say it in a sentence, but that's a kind of a detailed description of where we are today. Yes.
that the court is aware of public opinion
Mhm.
And that they may or may not actually consider that as a weighty matter, but that seems to me or somewhat by. And I'm not really sure where some days I think, oh, we're making progress, and people are studying theorize their authority, and then the next thing, we're not getting anywhere. So, I'm a philosopher, theologian, and, and I guess for a long time, people were working really hard to prove
Mhm.
but then I hear from the evolutionary biologists that that's a non-issue, that's a red herring. Of course, the terms, it's selecting conception,
Mhm.
because we have this zygote now, and there's no debate. So philosophers are all frantically trying to figure out how to prove conception when the scientists already have the basics. So my question is, what in your mind is needed, what kind of argument is needed to finally convert intellectually those people who are independent, that when you were born a baby did
Mhm.
not, what is going to change their minds? Who's watching TV on an iPad, not laughing at this, but
I understand. I am of the school that doesn't think that entrenched justices who have already made up their minds are susceptible to new facts or new intellectual arguments. I don't believe that as some would say, that the justices just need to see the evidence of fetal development and they'll say, oh my gosh, I didn't know that. Wow, let's overturn Roe versus Wade. I'm not of that school. Because
they would have done that already.
I agree, because they have seen the facts of fetal development in the two partial birth abortion cases that they decided in 2000 and 2007. They not only saw the facts of fetal development, they also understood exactly what happens in an abortion. Uh, so I don't think new facts about fetal development is going to change this court or the four Breyer, Ginsburg, Sotomayor, and Kagan change their minds about a right to abortion. But your question is, I think, fascinating because the philosophers are still arguing about persons and personhood and so forth. Medicine is much more clear, I think, than it was 20 or 30 years ago about fetal development and the beginning of the life of an individual human being. It's not human life, when does human life begin? It's when does the life of an individual human being begin? And medicine is pretty clear. But you know what's more clear than philosophy and medicine is the law. We have laws in 36 or 38 states now, fetal homicide laws, that protect the unborn child and treat it as a person or a human being in the law. 25 of those states, half of the states in this country today, and Minnesota is one of them, has a fetal homicide law that protects the unborn child as a human being or as a person from conception. We have laws in wrongful death laws. This is the tort side of the law, the civil side of the law. We have wrongful death laws in 36 or 38 states that apply to the unborn child, treat the unborn child as a person, because only wrongful death laws could apply to persons. That too protects the unborn child. So the law is even clearer, the statute law in this country, in the states, is clearer than even science or even philosophy about treating the unborn child not as an abstraction, not as a theory, but as a human being or a person in fact. And I think that's more powerful than even the medicine and the science, although I think science is very powerful. And those laws did not exist, or at least all of them did not exist back in 1972 or 3. The 36 to 38 states have mostly come about since Roe versus Wade. And the 30 or 36 states with wrongful death laws have mostly come about since 1973. And I have a chapter in Abuse of Discretion called The Cost of Schizophrenia. And I explain how the court in the abortion arena treats the unborn child as a zero, basically. But the states have moved ahead with these wrongful death and fetal homicide laws. That is also, to go to the origin of your question, that I think is a stronger indication of public opinion than even polling data.
See, this is what I was actually doing. I don't know, I couldn't but if public opinion has anything to do with it, what I'm is trying to get to the root of why it is that, why is the Supreme Court giving abortion? And why are all those women, when the minute you threaten or even hit, well, just as Susan B. Komen event, it's just one little event that tells you the whole story, right?
Well,
So,
I think public opinion has definitely moved toward the pro-life side. I think it's in part a development of the debate over partial birth abortion, which arose in 1995 in the U.S. Congress. I believe there's evidence that that debate over partial birth abortion has moved public opinion generally toward the pro-life side. If you look at the Gallup poll, Gallup annually, every May, it does a national survey on abortion, and it reports that data in May of every year. And since 2008, more Americans have or at least it seems like there's a growing number of Americans that self-identify as pro-life. Data showing that more Americans would like fewer abortions earlier in pregnancy. The data is also pretty consistent, as I point out in abuse of discretion, that despite the special interest groups, in fact, when you poll women versus men, women are more pro-life than men, and women are more anti-abortion than men, and women support stronger limits than men. So the divide is, I think, is artificial and political and not based on public opinion polling. It is, but part of the answer to your question is, I don't think there is one kind of like silver bullet that's going to change a justice's mind or the court's mind. We have to argue philosophy and personhood and medicine and fetal development and the court's disastrous tenure as the National Abortion Control Board and the growing data on the risks to women. We have to argue it all. Because, the court is, I don't believe there's any indication that this court or even perhaps a future court in my lifetime is going to basically flip the country and say, we're going to overturn Roe versus Wade and we're going to declare the unborn child to be a constitutional person. I think what the court will more likely do is say, there's no right to abortion, Roe versus Wade is overturned, and we're going to return the issue to the states. And the way to a constitutional solution or some amendment is through returning the issue to the states, returning it back to the democratic process, opening up the ability for public opinion and public policy and legislatures to pass limits on abortion and work through that process toward a national consensus that might support an amendment. But the court, Justice Scalia and Justice Thomas have made clear that they think the court should get out of what they call the abortion umpiring business, which means deciding the abortion issue either way. And they're certainly not going to get out of the business of deciding whether abortion laws are too loose to then decide whether they're too strict or not protective enough of life. The court's not going to do that. And Justice Scalia and Thomas are not going to do that. I can't believe Roberts and Alito, who have lived their professional life through the Roe versus Wade era, are going to do that either. And certainly Kennedy is not. So the most the court's going to do is eliminate Roe versus Wade and return the issue to the state and local process. Other questions? Yes, sir, in the back.
For centuries and for millennia, what suddenly happened
I explained that in abuse of discretion, because there was no record, no evidence, no trial, they were tempted and susceptible to latching onto untested, unprecedented theories of medicine, like the notion that abortion is safer than childbirth, but also unprecedented theories of history and law. And they latched onto the writings of a New York law school professor named Cyril Means, if you've ever heard of Cyril Means. Cyril Means, it wasn't widely reported at the time, but Cyril Means happened to be the general counsel for the National Abortion. I think at the time it was called the NARAL, the National Association for the Repeal of Abortion Laws. He was general counsel for them. He wrote some articles and filed briefs before the Supreme Court in which he said that abortion is safer than childbirth, and that these old laws that used to be in effect back in England and in the early American history were not intended to protect the unborn child. They were only intended to protect maternal health. And since we now know that abortion is safer than it was back in the 16th, 17th, 18th century, the maternal health rationale for those laws, those old laws, has become obsolete. And Justice Blackmun also latched onto, and the other justices latched onto this notion that the unborn child was not protected by criminal law, was not protected by abortion law, it was never treated as a real person, it was never really treated as a human being. Those laws were intended to regulate the medical profession, or they were intended to protect maternal health, but they were never really intended to protect the unborn child, and certainly not as a human being in person. And his theories have been repudiated over the last 30, 40 years with new research and the revelation of some new history and just some thorough scholarship. But they latched on to Cyril Means' theories, and Justice Blackmun cited Cyril Means 7 times in Roe versus Wade, more than any other historian that he cited. Another example of how no record, no evidence, no trial really skewed the outcome. Hope that answers your question.
I still find it very attractive.
It is, but here's another interesting aspect. Dorothy Beasley was the attorney for Georgia, and although Sarah Weddington has gotten all the publicity over the years, in part because she sought it, Dorothy Beasley argued for Georgia and was the most articulate of all the lawyers arguing before the Supreme Court in those cases. She argued fetal personhood. She argued fetology. She argued how medicine had grown to protect the unborn child as a human being in the womb. But ultrasound did not hit the market until 2 or 3 years after the Supreme Court's decision. And I think the justices were largely blindsided by ultrasound because they were not told about it in the arguments. They were not told about it in the briefs. It may have been developing as, on animals back in the late 60s, early 70s, but it had not hit the American medical commercial market until 75, 76. And if that had existed at the time, that might have affected the outcome. But clearly that has affected, American public opinions since 76. And that was, I think, another factor. Yes, sir.
Our goal is an independent judiciary, but you have a president who appoints, Democrat or Republican, somebody from his basically philosophic background, so you really don't have an independent judiciary. Would electing Supreme Court justices be more conducive to that, or I mean, because they can hardly be independent when they're appointed really by the President of the United States.
Well, The independence of the, but that's, that's existed since President Washington and President Adams and President Jefferson. And the justices were criticized back then because they were, so-called beholden to the presidents. President Teddy Roosevelt appointed Oliver Wendell Holmes to uphold the antitrust laws and to bust the trusts, and Holmes disappointed Teddy Roosevelt. So that's been a recurring issue. The independence of the Supreme Court is not premised upon how they're appointed. It's premised upon, whether true or false, it's premised upon the fact that they have lifetime tenure. And if they aren't independent before they get appointed, they become independent the moment they're confirmed. That's the theory of the Constitution, and we can debate that. There have been elections have been proposed, term limits have been proposed, and none of that has really gone anywhere. And that's a whole area that we could talk about all night. But that's my 2 cents on where that's going. Thank you very much for coming.
Okay, so this is what the book looks like when you're on Amazon, Abuse of Discretion. Is it in paperback also, or was that just the proof?
Not
that
yet.
I got?
That's
Okay.
right. It was just the
I
proof.
have